Greetings, everyone. Gotta make sure I got the sound going good here. Check. Testing A, testing B, testing 1, 2, 3. Looks like we should be going good. And let me check on this end. Oh, shit. Hang on. All right. Oh, shit. Hang on. There we go. Okay. We're live. Check. Testing. Okay. I think we're good. Welcome, everyone. Today we're doing the AmJur on public utilities. We're going to focus on rates, their duties of the people that are supplying these public utilities, their obligations, the authority is granted to them based on the privileges that they acquire with rights to things like water, gas, various utilities. And we're going to focus right now on how they go about regulating and rates, how they can charge customers rates, and how this all comes in. I'm doing great, guys. Thank you. We're going to focus on where the rubber meets the road. On part one, we were really getting into the essence of what a public utility is and why they exist in the type of entity that they are. Today, we're going to get on how the functions actually affect the people that they're serving. And that's what we're going to get into right away. So let's get right to it. And today, we're going to be helped out with Black's Law Dictionary to help us with any definitions we don't know, because we're going to leave no word behind. And, oops. I just try to get this zoomed in a little bit and looking good for the screen. And I think we should be good to go about now. And oops, let's get to the AmJur. And let me get this guy going good, and then we're going to start. Okay, so first part I want to get, we covered over the beginning on the last stream. Let's see here. Oops, wrong page. Oh, okay. Here we go. No, that's not right. Hang on a second. That's not the right page. Oh, sorry. That's why. Give me 1 second, guys. Shoot. Oh, man. 1 second here. Let me just change this out real quick. And give me just a moment. Damn. Okay, that one. Darn it. Thought I had this all set up, but I didn't. That happens. There we go. Okay. And we're off. Now we're correct. Okay, public utilities. Let's get started. We're all still there? Thanks. So page 42 is where we're going to start from here, and that's control by courts, injunctions. So first, we might know what an injunction is, but for those that don't, let's get right to Black's Law and figure out what is an injunction, especially in this context here, because you're going to find some different meanings for different contexts, different subject matter. And we're going to find out some, and inevitably, whenever we go on these little deep dives into words, I always leaving with more than I knew before I started. So even if you think you knew everything about a word, may not quite be the case. Injunction, 16th century noun, a court order commanding or preventing an action. To get an injunction, the complainant must show that there is no plain, adequate, and complete remedy at law, and that an irreparable injury will result unless the relief is granted, also termed writ of injunction. C, irreparable injury rule. We're going to come back on that. Let me just jot that down with a handy Esquire pen, and that's called the irreparable injury rule. All right. Is everybody still with me? It seems like I lost some people and I get lost on the wrong documents here. I hope everyone is still there in the chat. And give me some feedback here if everything is still working. See here, chat. Is anyone still there? Yes, great. Okay. Let's proceed. So let's read this here. In a general sense, every order of a court which commands or forbids is an injunction. We get this? In a general sense, every order of a court which commands or forbids is an injunction. But in its accepted legal sense, an injunction is a judicial process or mandate operating in personam by which, upon certain established principles of equity, a party is required to do or refrain from doing a particular thing. An injunction has also been defined as a writ framed according to the circumstances of the case, commanding an act which the court regards as essential to justice, or restraining an act which it esteems contrary to equity and good conscience. As a remedial writ, which courts issue for the purpose of enforcing their equity jurisdiction, and as a writ issuing by the order and under the seal of a court of equity. And that comes from a treatise on the law relating to injunctions, 1909. So while we're here, let's look at some of these kinds of injunctions now. Affirmative injunction, which is also a mandatory injunction. That sounds powerful. Anti-suit injunction, an injunction prohibiting a litigant from instituting other related litigation, usually between the same parties on the same issues. Ex parte injunction, 1854. A preliminary injunction issued after a court has heard from only the moving party, also termed temporary restraining order. That's an ex parte injunction, comes from 1854, and now we call it a temporary restraining order. So we just learned something new here, at least I did. Final injunction is a permanent injunction. Head start injunction, trade secrets. So an injunction prohibiting a defendant from using a trade secret for a period of time. Okay, we're not going to do patent law here. By the way, we don't do any law here. We're just discussing American jurisprudence here. This is strictly for entertainment purposes. There's no legal advice, lawful advice in any way, shape, or form, nor should anyone construe it as such or participate in implementing anything suggested here in any of their life in any way, shape, or form, and don't do this at home. That being said, let's continue. Injunction. Pedente light. Sounds like a good beer. Let's see here. Preliminary injunction is the interlocutory injunction. We got a mandatory injunction, 1843. Injunction that orders an affirmative act or mandates a specified course of conduct. That looks interesting. Also termed affirmative injunction, which brings us back to this one. Mandatory injunction. So let's look at this familiarity here. We have affirmative injunction, mandatory injunction, and where'd it go? Mandatory injunction. Affirmative. Okay, I get it. Let's see, permanent injunction does not necessarily last forever, just by its name. It's granted after a final hearing on the merits. From 1846. Perpetual injunction, see permanent. Preliminary injunction, a temporary injunction issued before or during a trial to prevent an irreparable, so this is before or during a trial, to prevent an irreparable injury from occurring before the court has a chance to decide on a case. Okay, that sounds good. A preliminary injunction will be issued only after the defendant receives notice and an opportunity to be heard. Also termed interlocutory injunction, temporary injunction, provisional injunction, injunction pendente light. Okay, so we can always look that more. Temporary restraining orders, the ex parte, we read that. Preventive injunction, an injunction designed to prevent a loss or injury in the future. Preventive. Interesting here. So far I see two good injunctions here. Preventive, the affirmative. Let's see, prohibitory injunction, 1843. An injunction that forbids or restrains an act. This is the most common type of injunction. Going to be a good one and good shot here. Good shot? Not sure what you mean. What kind of shot we shooting? Good shot? No, well, good shit. Good. Okay, cool. I like that better. It makes sense. This is going to be some good shit. We're just getting started here. The whole point is that this is the kind of background that we all need to have if we want to articulate what we're trying to intend and what we want to see as action. And this is the key to doing it, is to use these words. You don't need to say it well. You need to just say it right. And that's what I'm trying to go over here. So not only I can say things right, but we can all learn to do it together. Some of these words are just like gold, and just using them, they're literally magic words. The same things they try on us, casting their spells of words. It goes both ways. In fact, this is you could look at this as a spell book, if you will. Except this is the one they forgot to read, and we're reading it now. So let's go on here. Provisional injunction. We saw this, the preliminary, right? So this is another thing that you might want to do before a trial. Latin, because he fears. Oh gosh, it's a quietimate or quietimate injunction. An injunction granted to prevent an action that has been threatened but has not yet violated the plaintiff's rights. Nice. Reparative injunction. 1955. This is new. An injunction requiring the defendant to restore the plaintiff to the position that the plaintiff occupied before the defendant committed a wrong. Great. Another preventive injunction. So notice this. You got these different ones here. So we have a preventive injunction, right? We have affirmative injunctions or mandatory injunctions. So this mandatory injunction is an affirmative act that mandates a specific course of conduct. But this is something that's going to be done in a trial, right? Same with this permanent injunction, right? And it's not even forever. It's a final injunction. Again, this comes from the case. But if you need to do something before the case starts, look to 1828, a temporary injunction issued before or during trial. So what other ones are similar to preliminary? You know, we have a preventative and preliminary. You know, how about mixing these? Do we have mixed ones? Prohibitory, that forbids. Seems like this is the most common, but this looks like something done after trial, right? But if you're talking about preventive, you know, and this one over here, of course, the preliminary, a temporary injunction issued before or during a trial to prevent, so we're back to preventive, to prevent injury from occurring before the court has a chance to decide the case. So a preventive doesn't specify that. So perhaps when you make a motion to the court You don't use preventive motion. You ask for a preliminary injunction, not a prohibitory injunction, or a prohibitive injunction. Same with that. The prohibitory injunction seems like it's the most common type, but it's something that would be issued by a court. So, another one is this, the one that's hard to say, the quia timid, because he fears, like timid. Wow. Quia timid, because he fears. An injunction granted to prevent an action that has been threatened but has not yet violated the plaintiff's rights. So perhaps this could be some type of, what do we call it? Preliminary injunction. Keep this in mind here. This is for your notes. A preliminary, because this can be issued before. It's the only one I see here mentioning that specifically. And it goes back to 1828. And it's considered now also a temporary restraining order, which we know exists, but that harkens back to this. Also termed, look at this, interlocutory injunction, temporary injunction, provisional injunction. That's another one, provisional, injunction pendente light, ex parte injunction. So again, this is a very good one to know, preliminary. Let's keep that in the notes. All right, let's see what else we have here. So the reparative ones, right? Restore the plaintiff. Again, this looks like after a case has been heard. Historical, special injunction. Injunction in which the prohibition of an act is the only relief ultimately sought, as in prevention of waste or nuisance. Then temporary injunction. See preliminary. Beautiful, guys. So preliminary injunction, let that stick in your head. Unless you're already in trial, this seems like the best remedy for a situation. You could still use the reasoning here because, again, before an injury occurs, the same language is also here in a prohibitory. That's, wait, not that one. It was the preventive. In the future, this is the same kind of thing, but it just says it before, right? Has a chance to decide, right? And it's designed, right, to prevent irreparable damage, right? So notice the commonalities between these terms, the distinctions that none are overlapping entirely, and that way you can have a clear way of navigating this, because believe me, the other Esquires out there make lots of mistakes involving these wordings. And if you quickly notice this, oh boy, it sure makes them look like idiots no matter what you think you appear as. All right, especially to that fudge that's probably tired of seeing, jokers, go there and rope the public constantly. Every now and then, I think it might even satisfy some of these guys to see the people give these Esquires that have been just corrupted to the bone a run for their money. Let's proceed. I digress. Courts will control public service and other corporations in the use of their property only so far as is necessary to secure a proper discharge of the corporation's duty to the individuals or to the public. Moreover, courts will not enjoin the construction or use of public utilities and improvements at the suit of private individuals, unless the damage is both serious in amount and irreparable in character. However, an injunction may, in proper circumstances, be available to keep a public utility within the scope of its authority and to compel its obedience to the law. That dates back to 1922, North Carolina Public Service Commission versus Southern Power Company. Okay, so we could look that up there in the Fourth Circuit. All right, guys, are you still with me? I don't know if I have anyone left in the chat or if YouTube's lying. And I'm still online. Just making sure here. General duty to serve. So the primary duty of a public service, public utility, is to serve on reasonable terms all those who desire the service that it renders. It may not choose to serve only the portion of the territory covered by its franchise that is presently profitable for it to serve. The right to provide utility services to the public carries with it a concomitant duty to promptly and effectively provide those same services. Upon the dedication of a public utility to a public use, and in return for the grant of it of a public franchise, the public utility is under a legal obligation to render adequate and reasonably efficient service impartially, without unjust discrimination, and at reasonable rates to all members of the public to whom its public use and scope of operation extend, who apply for such service and comply with the reasonable rules and regulations of the public utility. On the other hand, the obligation of a public utility to serve the public is limited by the extent of the profession or undertaking by the utility to serve the public. Okay, and I'm pretty interested here in number 5. Okay, in here. So we'll have to look at the other sections there. 133. Let me write this down. Maybe 133. Jeez. And 132. All right, is everyone there? You could leave something in the chat so I know you're all there or someone's there. Is anyone there? Is my audio on? Check. All right, let me just double check stuff here. Make sure we're still streaming. Refusal of service because of collateral matter. Here's a right to cut off water supply because of failure to pay sewer service charge. And that's another volume. A public utility corporation cannot refuse to render the service that it is authorized by its charter to furnish because of some collateral matter not related to that service. Thus, for instance, the proprietor of a summer resort who sells cottage lots and who undertakes as a public utility to supply owners with water and light cannot refuse to furnish water and light to a lot owner because of his or her refusal to comply with a rule requiring such owners to provide septic tanks for the disposal of sewage. Nor can a municipality attempt to collect a delinquent garbage disposal bill by shutting off the water supply of the patron. And that's Garner versus City of Aurora, Nebraska, 1948. All right. Is anyone still there? I'm not sure I'm even still streaming. So please put something in the chat, anything, just so I know I'm not talking to the ether. And we're broadcasting to the interwebs. All right, thanks. At least we got someone there. This is real powerful stuff, guys. I'm surprised there's so few people out there. I think it's shadow ban. This is stuff people don't want you to know. So, nor can a municipality attempt to collect a delinquent garbage disposal bill by shutting off the water supply of the patron. An electric company may not cease to serve the public because a city, in constructing a competing system, has created conditions rendering continued service dangerous and refuses to alter them. Again, in the absence of some qualification in the charter of a public utility that undertakes to perform two distinct kinds of public service, reserving to it the right to furnish one kind of service only when the other is also furnished, the public utility has no right to refuse to furnish one kind of service without the other. And this is true even when one service is a byproduct of the other. I guess water and sewage, right? A like limitation applies to municipality offering two distinct kinds of public service. Interesting. That's number 7, footnote. Idris versus Sebring Utilities Commission, Florida, 2nd District, 1970. Dale versus City of Morganton, North Carolina, 1967. So, well settled. Duplication of service. Generally, when a patron of one public utility is being satisfactorily and amply served by that utility, another utility cannot be compelled to duplicate that service at great expense. This rule has also been applied to a municipality furnishing a utility service. The reason for the rule is the aggregate cost or inconvenience to the public that the duplication of service would ultimately entail. So, observation. A Public Utilities Commission will condition permits so that there is no duplication of service. The mandate to avoid duplication of service is known as the doctrine of regulated monopoly. All right, so we're not going to get too much into this. And we're going to move along here. Okay, yeah, so now we're going to jump to the next section I want to get to, because this stuff here is going to deal with the commissions. And I don't think any of us are on the commission this month, so let's move along. Let's see, page 1, 318. All right. So let's move along here, generally. Certificates of convenience and necessity are issued to public utilities to regulate competition. That is, to prevent unnecessary duplication. So that's kind of like where we left off and skipped all that stuff over. Doctrine of regulated competition. So this is the detail that we just went over. Not planning to dive into this unless someone tells me I should now. Otherwise, I'm going to move on. Okay. (164) What constitutes necessity? The public need required for the issuance of a certificate of public convenience and necessity is not strict need or strict necessity. A certificate should be granted if the utility would serve a genuine... Okay, this is one I want to skip over to. Power to fix or regulate, generally. Public service commissions are generally given the power, under statutory or constitutional provisions, to review, approve, or fix public utility rates, usually under the direction that such rates must be just and reasonable. Let's look at this a little deeper here. Oh boy, it's going to get deep. Woo! Yes. High speed, ferry, 19. Nice, okay. And then 2 is Georgia Public Service Commission, again, 1998. So something was going on then. 97. All right. Again, we're looking at 2022 update of American Jurisprudence. So we're looking at some pretty recent stuff. So to see that nothing's been changed and, that 30 some odd years is almost 30 years is good. Let's see here. A Public Utilities Commission has the authority to accept and rule on an application for a rate increase submitted by an organization of companies. The Commission is not required to process applications on an individual basis. Okay, so a Public Utilities Commission has discretion to decide what factors it will consider in setting or evaluating a utility's rate. It also has broad discretion to ascertain the value of a public utility's assets and is not required to use any particular kind of evaluation method. So, all right, let's get the observation here. Statutory provisions delegating rate making or rate regulating authority to public service commissions have been held to be constitutional and valid delegations of such power. So, again, no one can be making rates or regulating, right, without having approval all the way up from statutory provisions to the Public Service Commission. down to the actual people that are charging the rates. However, the power to fix prices and make rates by a commission cannot be conferred by implication. It must be conferred under statutory or constitutional language. See, they can't, all right, that is free from doubt and that it admits of no other reasonable construction. 7. City Public Service Board of San Antonio versus a Public Utility Commission of Texas. Geez, 2001. Let's look at the cases here for this cumulative supplement. The Public Service Commission's non-compliance with Base Load Act, including mere construction work in progress in electric utilities, rate space, and rates, resulting in utility charging increasing rates, violated ratepayers' substantive and procedural due process rights. Commission deprived ratepayers of their property, i.e. money. You get this? All right, I need to just dwell on this for a second if anyone's paying attention still in the chat there. This is where the case, this is how it's constructed, and they're not going to point this stuff out in American jurisprudence. If they're saying cases and they're laying this out, this is a story in itself. You got to read into this. Okay, so the Public Service Commission's non-compliance with, like, they have to know about this Baseload Act, and including mere construction work in progress in electric utilities, rate base, and rates, resulting in utility charging increased rates. Guaranteed, somebody knew about this. That's never by accident, I don't believe. Violated the ratepayers' substantive and procedural due process rights. So how were the damages? What were the damages in your cause of action? Who was at fault and who was the one injured? Well, the commission, they caused the ratepayers, I love it, to be deprived of their property, money. And it did not require notice to taxpayers, to ratepayers. So, good stuff. Did not require notice. Just the fact they did it put them on the table there for a cause of action. They deprived the ratepayers of their property, money. So do you understand how this is constructed here? And they did it because they did not require notice. They just went ahead and did it, seems like, right? However, the power to fix prices and make rates by a commission cannot be conferred by implication. It must be conferred under statutory. See, the statutory provisions delegate rate making. So it has to be conferred under statutory or constitutional language that is free from doubt and admits of no other reasonable construction. So it must be conferred under statutory or constitutional language. So see, the power fixed by commission cannot be conferred. So statutory provisions. So you got to look at your state and see the statutory provisions delegating rate making or rate regulating authority. Because that's going to tell what the Service Commission can do, right, to fix rates and prices. Can't be done just by implication. Must be conferred under statutory or constitutional language. So that has to be in whatever they're claiming. Let's continue. Oh, another case. Public Service Commission's non-compliant. Oh, this is what we did read. Beautiful stuff here. USCA Constitutional Amendment 14. Wow. Okay. So good stuff to research on that too. And now we're on to retroactive or prospective rates. Interesting here. In many jurisdictions, the power of a Public Service Commission to prescribe rate changes is prospective only. Okay, so for utility rate-making purposes, however, a prohibition against retroactive rate-making applies only to base rate proceedings and not to surcharge proceedings. Also, if a court affirms a utility commission's rate-making order, the rule against retroactive rate-making provides no obstacle to giving effect to that order as of the date provided in the order, particularly if the rates set by the order would have gone into effect at that time, but for the filing of a removal action. Recalculating rates. So this is more on the commission side. So let's just keep moving on here. All right. Light turnout tonight. Refunds or rebates? Okay, so the commission can make them do rebates and refunds. Rates of municipal utilities. All right, now we're in consonance with the difference in result as to the jurisdiction generally of public service commissions over municipally owned and operated utilities. The cases are divided as to the power of public service commissions to regulate the rates of municipal utilities. Thus, it has been held that a public service commission has a power to regulate the rates to be charged for public utility service by a municipally owned or operated public utility. However, it has also been held that a public service commission does not have the power to regulate the rates for service rendered by municipal utilities in general, or for services rendered within the corporate limits of a municipality owning and operating a municipal plant. So let's dive into this a little bit here. The difference in result as to jurisdiction generally of public service commissions over municipal owned and operated utilities. The cases are divided as to the power of the public service commissions to regulate the rates of municipal utilities. Cases are divided. See, thus has been held that a public service commission has a power to regulate the rates to be charged for public utility service by a municipally owned or operated public utility. However, it has also been held that a public service commission does not have the power to regulate the rates for service rendered by municipal utilities in general, or for services rendered within the corporate limits of a municipality owning and operating a municipal plant. Where's third party come into that, I wonder? So let's look at these cases here. Well, there's only three. 1, 2, 3. So section, okay, we could look at that. Pabst Corporation versus City of Milwaukee, 1926. That's a good one. Let's see. Public service has the power to regulate the rates charged. Okay. Wow. So this would be interesting to read up on. And then 3, Shirk versus City of Lancaster, Pennsylvania. And that was 1933. And American Aniline Products versus City of Lock Haven, another one, Pennsylvania, 1927. Again, Texas, 87, denied 88. Okay, so rate schedules. Public utilities may be required to file schedules of rates, also known as tariffs, with a public service commission. So you request the tariffs, like what this guy knows what he's talking about. Statute giving a public utilities commission the power to alter, amend, or suspend rate schedules is a valid delegation of the police power and does not constitute a deprivation of due process and equal protection. They're talking about police power over the public utilities, right? It does not constitute a deprivation of due process, right? So the overriding purpose of such a statute is to seek to assure to the greatest extent possible, listen to this, this is the purpose, the overriding purpose, that effective rates shall be just and reasonable rates. Number 3. New England Telephone Telegraph Company versus Public Utilities Commission, 1977. Good old days. Okay. Public utility rates filed pursuant to a statute with a public service commission or promulgated by the order of the commission in accordance with the statute have the same force and effect as if directly prescribed by the legislature. So, order of the commission in accordance with the statute, just as they're prescribed by the legislature, and bind both the public utility and its customer. Pursuant to a statute or promulgated by order of the commission in accordance with a statute. So we're back to the statute of your state. So that's why American jurisprudence isn't going to tell you what the statute is, because guaranteed if we were reading state statutes, no one would stick around this long for however many people are still here. This is the homework you do for your state. Look up the statutes regarding public utilities. And believe me, there's a lot to read there, and you'll have to do that on your own because it's boring. This is the good stuff. Public utility rates filed pursuant to a statute with a public service commission or promulgated by order of the commission in accordance with the statute. So regardless of who was done, that statute is the primary decider here. Have the same force and effect as if directly prescribed by the legislature and bind both the public utility and its customer. So the statute, remember, we all agree to the statute, but it goes both ways. Under the filed tariff doctrine, there is a conclusive presumption that both a utility and its customer know the contents and effects of published tariffs. Number 6. That's Teleconnect Company versus U.S. West Communications, 1993 in Iowa. Neither a customer's ignorance nor a utility's misquotation of an applicable tariff provides refuge from the terms of the tariff. So a customer has no cause of action against a utility for negligent or intentional misquotation of a tariff service. And any agreement to provide a tariff service on terms other than those set forth in the tariff is void. Powerful language on that last sentence, guys. All right, we still got people in here, right? If you guys could hit a 1 in the chat or pose a question, something like that, so I know I'm still broadcasting to the interwebs. And you're all looking at the same thing I am. So there's a filed tariff doctrine, conclusive presumption that both utility and its customer know the contents and effects of published tariffs. Okay? Neither customer's ignorance nor utility's misquotation of an applicable tariff provides refuge from the terms of the tariff. So a customer has no cause of action against a utility for negligent or intentional misquotation of a tariff service. And any agreement to provide a tariff service on terms other than those set forth in the tariff is void. Any agreement to provide a service on terms other than those set forth is void. So let's see here. Same case. And we're on to generally. State statutes generally require utilities to get approval from the Public Service Commission before selling their securities or significant portions of their own assets or mortgaging their property. Some state statutes, however, do not require a utility to secure approval from the Public Service Commission before obtaining short-term credit. Whoa, so they're obtaining short-term credit with our waters and electricities and gases? Yeah, let's read these footnotes. Okay, it's all in here. We get to that next. Holy shit. A Public Utilities Commission has a role in determining whether proposed financing for a utility is for the public good, and that role encompasses considerations beyond merely the terms of the proposed financing. However, a Public Utility Commission's statutory authority to impose conditions on a public utility's use of its financing proceeds is limited. Its use of them, obtaining them is different. Get approval before selling securities or or mortgaging. Wow. Heavy stuff here. Sale of assets. We could probably skip over this. Someone's buying anything like that. Stop me if anyone wants to go over the sale of assets. Mortgages, deeds of trust, foreclosure sales. So yeah, this is if they're foreclosing on their utility. Generally, state's power to determine whether Public Service Commission may issue securities. So we're going to skip over this one too. Issuance, sale, and stocks and bonds. Yeah, we're not going to go over that either. Transfer of outstanding. All right, so I think we've pretty much reached where we need to go. I want to go over all those parts there. And here's part here is the Public Utilities Commission rules, procedures, how they force. Okay, let's read this one here real quick. A Public Utilities Commission, which section is this, by the way, so we know? Back to generally, section 176. Anyone still out there in the chat? If so, please hit the like. All right, let's proceed. A Public Utility Commission's rules of procedure have the force and effect of law. Commission's rules of procedure. So that's the other homework, your state statute pertaining to public utilities and the commissions for your district or municipality or wherever your public utilities district is. That commission's rules, the Public Service Commission's rules of procedure, have the effect of the force of law. So these are considered law. As Public Service Commission of Oklahoma versus State Corporation, something there, okay, Loving, 1996, Oklahoma. The Commission has the discretion to decide how, in light of its internal organization and docket considerations, it may best proceed to manage and expedite the orderly flow of its business, avoid undue delay, and eliminate an unnecessary duplication of effort. Cases. When settling the rate of return for an electric utility, the Public Service Commission was not required to use a proxy group of utilities to determine an appropriate capital structure. Okay. We're not going to get into that unless we're funning these characters. Assistance for consumers. All right, here we go. A federal statute creates a system of grants to assist consumers in their presentations before public service commissions. The grants are to be administered by an Office of Consumer Services, which is independent from the Utilities Commission and which is authorized to assess the impact of rate changes, assist customers in their presentations before commissions, and advocate for consumers. No shit. USC, 42 USC. A federal statute creates a system of grants to assist customers in their presentations before, guys, grants says money. Grants are to be administered by an Officer of Consumer Services. Where we go. It's independent and is authorized to assess the impact. Man, assist customers and advocate for consumers. 42 USC. Anyone wants to check it out? Section 6805A. Damn. Not-for-profit organizations had standing to bring an action seeking an injunction against the state attorney general's policy of denying funds under 42 USC to consumer groups who had lobbied in a preceding session of the state legislature. Sweet, 1979. All right, so I hope everyone caught this one here. The federal statute creates a system of grants. A system of grants. And that's one, the federal statute. There it is, 42 USC. Write that one down. We're coming up with some good stuff in this one. All right, let's see where we are now. Due process, notice, and hearing. Some statutory or constitutional provisions applicable to proceedings before public utilities commissions make notice and hearing prerequisite to action by the commission, particularly if there is a dispute concerning a material fact in a contested case. So we got to see there's some statutory or constitutional provisions applicable to proceedings before public utility commissions. Make notice and hearing prerequisite to action by the commission. So they have some provisions that they have to do. As a general rule, a public utility must be afforded some opportunity to be heard as to the propriety and reasonableness of the rates fixed for its services by the commission. Furthermore, a public service commission cannot, in a general investigation made for the purpose of promulgating rules and regulations, revoke, amend, or alter permits or certificates of participating parties. It must comply with the statutory requirements of notice, hearing, and a decision made in accordance with the evidence. So number 3, Public Utilities Commission 1968, Colorado Motorway. However, a Public Utilities Commission may use rulemaking proceedings to affect rates without conducting an adjudicatory hearing. So they have to have they can use rulemaking proceedings to affect rates, right, without conducting an actual adjudicatory hearing. Learn to pronounce this word on a previous stream here. All right, so let's see here. You got to look up the constitutional provisions and the statutory. And that's back to number 1. And what statute they have here, I don't see it. Okay. You got to read the case text and you'll find that stuff. That's 1996. To be considered sufficient, notice by a public service commission to a public utility in advance of a hearing for the purpose of making an order affecting the utility must state definitely the order the commission is proposing to make and the reasons for it, so that the utility will be enabled to produce and present before the commission its evidence, if it has any, showing the impropriety of the proposed order. So notice by a public service commission to a public utility in advance of a hearing, so the utility will be able to produce and present its evidence, if any, showing there's impropriety. A published notice of the time, place of the hearing, and the substance of a petition for the establishment and maintenance of a proposed public service corporation substantially complies with the statutory requirements if the statutory purpose is fulfilled. That is, if all the potential customers and other interested persons are adequately informed of the nature of the proceedings. Petition of Cable TV, Vermont, 1982. All right. Guys, we just finished a huge volume here. We skipped over a lot of the stuff here involving the politics and that kind of stuff, but to go through the 64 American Jurisprudence, 2nd edition, Public Utilities. It's a good accomplishment that we have a better understanding. There's more to it than just this, but at least we got through this part of this volume here and learned a lot about the fundamentals of the intent, the purposes, the regulations, the duties, the obligations that public utilities as an entity are required to do. And in turn, they are granted property rights to precious resources, which are truly the people's. So in exchange for that, there are certain duties and obligations that they're compelled to do by law and by constitutional laws too, that there's no way for them to get around legally if we're hold them to a cord. Now, I believe that there's been some time that this has just gone on too long without people recognizing some of these fundamental requirements of these public utilities, in that relying strictly on the public service commissions and such haven't been really doing what was required to be done. And it's up to us, the people, now to stand up and assert our rights and stand up for what we have promised to us in the form of their obligations and duties so that they can have the authority to make the profits that they are permitted to do under law by a just and equitable agreement that we are supposedly regulating through public service commissions. Now, before anyone wants to demean or say anything bad about the public service commissions, we just learned tonight that there's federal system of federal grants to help us as the consumers or as the people to address these public service commissions and to make sure that we have advocates for us too in that realm that will compel them to follow up on their obligations and duties to the people that have permitted them the authority they have over the public property. That being said, I really appreciate anyone that did show up and enjoyed this little exploration with us. Definitely something that needs to be disseminated to the people out there. I've found out there's a general feeling right now that people are not satisfied with the way their public utilities are operating. And the public service commissions and such, the public utility commissions, don't seem to be doing enough to stand up to the people and fulfill their obligations either. And considering that the federal grants are there waiting for the people to basically put the fire under the butt of the commissions or to stand up for ourselves for these in front of these commissions, which do have their authority by law to regulate and to control these public utilities and basically to protect our property in many forms, especially in the form of money, and that none of them engage in any type of injury that causes us loss to our property or harm or injuries in any other way. Because what we've also learned is that becomes a cause of action for remedy through both equitable actions of injunctions and through civil actions for monetary rewards. On that note, I want to thank everyone for coming in again. Again, I just want to remind you this isn't for any kind of legal lawful advice at all. This is strictly entertainment and for a little bit of an enjoyment of a research and a discovery into American jurisprudence. On that note, I appreciate you all for coming. We got LA Spike in house, finally. You made it. Hope you took notes. We had a lot of good note taking tonight. And I'm sure everyone's going to want to watch this again. And I'm sure I will for my own notes because there's just been a whole lot to learn. I definitely did, and I hope you all did too. And on that note, I want to thank you for coming, and I'll see you all in the next one. Peace out.